you will use my experience and we will take it from there. Thank you. Our lecture today starts with we are going to deal with criminal court practice, of which our introduction will then start with people most of the time think that the only time when we deal with criminal procedure is when one is at court. But the minute one person gets arrested is then that the criminal procedure starts to kick in. And before I forget and we go further with our lecture today, I would like to apologize that this program was scheduled for 5 days. However, I will not be able to deal with this for 5 days, but we will do this in 4 days. So, but all the work that needs to be covered in the 5 days will definitely be covered in the 4 days that we will then be attending. Let me then go back to the criminal to our introduction. As I indicated, the criminal court practice starts the minute you are then approached to assist a client. Who approaches who? Either you are approached by family members, friends, or any other person who needs someone who is being arrested or detained, needs legal help. So once that person needs legal help, whoever will then approach you as a legal practitioner and will give you information as to where the person is being arrested, which police station is this, when was this person arrested, for what offense is this person allegedly being suspected of. Once this person, you take instructions, then you then go to where the person is, then you have a one-on-one session with your client, whereby the client will give you his SAP 14, notice of rise. He gets that once he is being charged. Once the person is being charged, is in possession of the notice of rights, he knows what is it that, what are the charges or prospective charges or allegations the police are then putting forth. Then from there, you know, what is it that I need to do for my client to then be released? Don't forget, this is before the client is even at the in court. Then you then secure that if your client is facing a Schedule 1 offense, meaning then that your client doesn't have any previous convictions or pending cases, his address has been verified, because that is very important. Address verification of your client so that your client can then be traced. Secondly, the profile of your client. Does your client have any previous convictions or any pending cases? If yes, then we will know which route to follow. Either it's a Schedule 1 offense or it's a Schedule 5 offense. Then, if your client is facing a Schedule 1 offense, now the prosecutor, there are prosecutors who are on standby. Then they will then establish as to whether this person is a suitable candidate either to be released on bail or not. Then if yes, then the prosecutor will fix bail for this person, and then this person will then be released. So this is the first stage of what happens before the matter is being to court. Then we then proceed. Your client is either released on bail or your client is given a notice to appear in court, then the client will be given a date as to when should he then come to court. So once that person then comes to court, you know that first thing that you do, you then have to then approach the prosecutor in court who is dealing with the role on that day. Then you then discuss the merits, find out from the prosecutor as to whether this person has, if the prosecutor has the docket of the client you are there to represent, and then from there you discuss what is the way forward in the matter. Is the matter going to still be investigated further, or are the investigations being finalized, or if then you guys arrange a date as to when will then the matter be remanded to. This is what is happening in court. Then the matter is going to be called in. You then appear in court. You confirm your appearance in court, and then you confirm the postponement for whatever the reasons the prosecutors would have agreed with you upon. Don't forget to then say that the state is dominus litis. Whatever they would want to happen with the matter, they will escalate it to you to then say to you that, you know, my investigations are not yet finalized. We are of the view that we still need some time to investigate the matter further, or there are still witness statements that are still outstanding. Then you agree, confirm your appearance in court, confirm the date, then the matter is then postponed to that date. And please, please, please don't forget to request the court to either extend your client's bail to the next court appearance, or your client to be warned further for the next appearance. Because most of the time...
Are you sharing a presentation? Are you sharing a presentation, or is just a blank screen? We're not seeing a presentation on the screen, except
oh, you're not...
those.
Okay, do you see the presentations now?
We're just seeing those 4 points, saying introduction, taking instructions, indictment and charge sheet, and indictments and charge sheet. That's all.
Yes.
Oh,
yes.
okay. Okay.
I'm still elaborating on that.
Okay, sorry. Thank you.
Okay, if you can see the first point is a legal practitioner is approached to assist the client. And then I elaborated on that any family member or friend or any other person can approach you to help out. Are we on the same level?
No, sorry, we can't see that. We are only seeing 4 points on the screen saying introduction, taking instruction, indictment. So the PowerPoint presentation is not open.
It's not open.
No, we're totally lost. We don't know where we are now. We don't see anything.
Okay,
I didn't think she was presenting. I thought she was just talking.
Let me try to sort it out for you. Can you see it now?
Yes, ma'am.
Yes, we can see it now. Yes.
Okay. So
I was still on. Everything is just gone quiet.
Still here.
Still here, but can't hear the lecturer.
Good afternoon, everyone. Okay, I see she is out. I'm asking her to come in again, to log in again.
Ladies and gentlemen, I'd like to apologize for technical errors that I've encountered from my side. I'm humbly sorry about what happened. I would like to take you back to the introduction about our course today. As I indicated to you that I'm of the view that we need to do it in more of a practical nature.
Are we still online?
I think she's having
Still
technical.
here. Still here.
It's there, could be network related.
Can you hear me now? Ladies and gentlemen, can you hear me now?
Yes, we can now hear you.
Okay.
Yes.
As I say, my
I think if you
apologies.
can switch off your camera, Your network will work better.
Or if I switch off the camera?
Yes.
Okay, thank you. I did switch it off. As I said, I would really like to apologize for the technicalities that I've encountered. However, what will happen is I've prepared some slides of which I will provide the slides to Zuki, and we will then forward all the presentation slides to you guys in a due course. As I said, again, I would like to apologize for that. Before we were interrupted, I would like to introduce this module in a different way and deal with this module in a more practical nature of what happens in a criminal court practice. Like as I indicated to you guys, to then say that everybody can read the manual. We all went to university, we know our substantive law, but this is more as to what needs to happen in a criminal court. Should you then be engaged with clients who wants your assistance in respect of a criminal matter? What is expected of you? Where do you start?
I'm sorry to disturb.
Yes.
There's someone that is in the waiting room that can't come in the lecture.
Okay.
Thank you.
Thanks. Yes, we did attend to that. Thanks for letting us know about that. So as I said, let's deal with this in a more practical way. As you know, what will you do should you face with a client coming to you or with a family member coming to you and requesting services from you? As I said, this is my brief introduction as to you will then be approached by someone, either a friend or a family member or a colleague, letting you know that someone has then been arrested. The starting point is, where do you go once you get that information? You then ask, where is this person? Which police station is he or she are kept? And what is the charge against this person? Then you then go. First thing, you have to try and see to it that you have to get your client be released. How will your client be released? Either your client is released on warning or your client is released on bail. But this is established at the police station. First thing first, the police officer who is on standby has to see to it that your client's address is verified and the profile of your client is verified before the prosecutor who is on standby as well can fix bail. If it's a petty offense, then the police officers can even warn your client to come and appear in court the following day. Once your client is released and he is out either on bail or on warning, then your client comes to court. When you are going to meet with your client at court, and it's your duty as the legal practitioner to then approach the prosecutor who is dealing with the role on the day in question. Then you arrange with the prosecutor, find out how far the matter is. Then the matter is going to be called in court and be postponed to the next date for whatever the reason is. Either the matter is being postponed for further investigations, or the matter is then being postponed to for you to get copies of the docket. We call it disclosure, and or the matter will then be postponed for you to then get instructions from your client as to what the way forward in the matter is. Then whatever the outcome is, you attend to it, then the matter is then finalized. either your client is given a diversion program, charges are withdrawn, or the matter is not even placed on the roll. There are various ways of disposing matters, of which we'll deal with them at a later stage. Then
Are we still on?
Yeah, it looks like she has connection issues, network issues or something.
Yes.
But that slide also that she's got, we can't even see it because they've got this thing where they're accepting meetings. I don't know why she's the one accepting the meetings and disturbing the lecture at the same time.
Wonder what is happening.
Yeah, I also think the slides need to change because we're only sitting on page 1.
How about she emails me the slides and then I share with you guys instead of her having slides on the screen? Because I don't understand exactly what is the problem. I think she must email them to me. Yeah, I think that would be better. And again, the number, I think also the number, it's affecting us. But let's see what we can do. Let me call her.
Hi,
Thank you,
Takisha.
Hi.
Sorry, I just want to find out, will you be uploading the sessions right after each session at night, at that same day?
I can't do it at night. It will be tomorrow.
Oh, okay. So you will upload it the next day.
Yeah.
Thank you.
Can I call her so that she can come back? Maybe she's still talking alone there.
Yes, please. See what you can do.
Still quiet. Is she coming back?
yes, I'm coming back. Technicalities is not on my side, but however, I've been assisted here. But as I said, I'm so sorry about the issues that I'm coming upon, because I switched the camera, but it keeps on kicking me out. So I'm not sure what the situation is all about, but we are trying to sort it out with the coordinator from the other side. Sorry about that. So if I may then continue, that you represented your client, you fulfilled your mandate, then your mandate then ends. So either it ends by you finalizing the matter as expected, or sometimes the clients are not so happy, because if you can't provide them with the sentence or the outcome that they need, they will say, no, I'd rather go and get someone else. But however, even if you tried your best to advise them accordingly, they will then still feel that, no, they expect a certain outcome from you. Forgetting to then say then that it's not upon you, it's upon the sentence is with the discretion of the court. As I indicated to you earlier further, to then say that the state is the one whose dominus litis. If they are of the view that they have a prima facie case against your client, definitely they will try to go forth and proceed with the matter. So expect this from clients. Clients will come to you dictating to you as to the outcome of their matter, how it should then be, irrespective of the evidence that is before you. Even if you explain to them to the best of your ability, then they will still want you to perform miracles, of which that's what we come across on a daily basis. And even after they have already either terminated your mandate or you are done with your instructions and you fulfill them accordingly, they forgot to then say that, oh, earlier they were so mean to you, or whatever the situation is, they will still come back to you and ask for your opinion or advice on something else. So as a professional, you maintain your cool and you advise them, because for me, reputation goes a very long way. So that is what happens as with regard to the introduction as to what happens. Then we furthermore proceed to the time when you consult with your client. When taking instructions basically is consulting with your client. You have to then make an appointment with your client, have to see your client in your chambers, and then from there have to then take instructions, hear what the matter is all about. Furthermore, we have different sources that we use in our criminal law, criminal procedure, whereby they do help us in going through, preparing for our cases and so forth. So what do we then do? We then have to rely on the Constitution. The Constitution is the supreme law of our country. Everything that needs to be done has to be in accordance with the Constitution. You don't have to then infringe your client's rights, or it's your duty furthermore as the legal practitioner to see to it that your client's right, you protect the best interest of your client. So we take notice of the Constitution. We further take notice, as you can see there. Oh, they can see. Okay. Oh, as I said, we will provide you with the slides. Then there are sections that are very important. Section 2, which says the Constitution is the supreme law of the land. Section 172(1)(a), which bestows powers to the courts. The Bill of Rights. Chapter 8, the judiciary. More important in criminal matters is Section 35 of the Constitution, which deals with the rights of a detained person. This is very important. You can have evidence in terms of your criminal law, how the elements of the offense have been proven against your client. But if Section 35, the rights of your client are infringed, then you know that, you know what, you have a very strong leg to stand on, whereby you will then have to advise your client properly in terms of that. Even if your client has committed an offense, he's innocent until proven guilty. So his right to dignity has to be taken, it has to be of a very important, taken care of, because if one's rights or one's dignity is being infringed, then we are going nowhere. Then that poor person is like being treated as nothing. And we already know that some of the police officers, they do take information or evidence not in a right way, of which the way they obtain the evidence, they are infringing at your client's right to dignity. Same applies to freedom and security, the right to privacy. So don't forget more. The most important again is the limitation clause. Even if your client has the right to dignity, to all the rights in the Bill of Rights, but don't forget to then say that all rights have limitations. Then we rely furthermore on other statutes. The most important thing is the Criminal Procedure Act. There's this Juta pocket book, which is very handy, that you will have to carry on with you at all times. Should there be something that you quickly need to refresh on, you can then quickly go through it and see to it that you research whatever the section that you want. It's not only the Criminal Procedure Act, we even have now the Criminal Law Amendment Act, we have Sexual Offences Related Amendment Act, the Child Justice Act, and so forth. As I said, once we then forwarded you the slides, you will see what I am now talking about. So in a criminal trial, or if you have a criminal case, have your Criminal Procedure Act, have your law of evidence with you, and then come your constitution. That's when now everything you know that they will then become they will come handy to you. Furthermore, we even rely on the common law. As you know that our law develops on a daily basis, then we come from the English law, but however, we don't forget what the Section 39 of the Constitution says, which says then that the court may have regard to foreign comparable case law. It doesn't only mean then that you have to rely in only our South African case law. There might be one of the neighboring countries whereby there is a case law which is relevant to what you are dealing with. Then you will then have to then go through that, apply that case law. It will be helpful to you. Furthermore, are we together? Hello, are we still together?
Yes, we are. We can ask the others to mute their mics, as some people don't have the mics muted. Yeah.
Yes.
Yes, ma'am.
Okay. I think if we can all other students mute their mics.
Can Sally please mute yourself?
Pardon? Yeah, as I was saying, case law is very, very, very important because our law develops. If you can see, the Criminal Procedure Act was written in 1977. It's been long time. But then how does it develop? It develops through cases that are being decided by our different courts on a daily basis. And where do we get our cases? We get them through our South African law reports, through our South African criminal law reports. You can even go through your butterworths as well, and SAFLI will help as well as to determine what cases we have or that are decided on a daily basis. And the other thing that I would like to stress is that please do not take things for granted. Prepare for your cases that you need to appear for. Go and do your research. Go and do case law. And there are various textbooks as well that have all the latest information that will help you as well with regard to the developments in whatever the field or the the section rather that one will then be pursuing. Furthermore, articles and other sources where people who are doing their masters as well as their doctorates, they go into an in-depth research as to dealing with a specific topic, and then with that they will then be able to do a homework, and then they will then be able to know what is it that they will have to cover. So if there are articles, you can use them as well. They will then have to help you in strengthening your case so that you can then be able to help your client in coming out from whatever the section, what the problem is. As I said to you, the textbooks, we have various types of textbooks, Neyman's and the commentary by Ziefeld, Van den Berg. There are so many authors. If you can check in your study guide as well, then go through all the necessary textbooks. But on what I can say in terms of textbooks, just go through the latest edition. Go through the latest edition and see if whether you will then be able to see what is it that the courts have now decided upon. Then do you have any questions as up to so far? Hello?
Yeah, are we right?
No, thank you.
Are we right in saying that the slides are still not showing on the screen? Is that correct?
I can't hear you.
Are the slides still not showing on the screen?
On my side, they are. I'm not sure from your side if they are not showing, but as I said, the coordinator will try to facilitate that and help us through. But as I said, we will try to forward them to you.
I suggest that we share the slides on the chat, then everyone will have them.
Okay, I will canvas that with Zukiswa, and then we will take it from there. Is it fine with you guys?
Yeah, even if she can email,
Yes,
we can access our emails and print or share our emails while we are listening to you.
Okay, all right. Okay, we'll facilitate that to her, then email that to her now, and then she will then have to then send it through to you guys. Are we all sorted? Any other question or any other concern?
Yeah, I think that there's also no, just trying to work out why your slides are not showing. So are you sharing it from your side?
Yes, yes, but then as I say, I'm not sure what the problem is, because I've clicked the share here, but it doesn't go through. But as I say, we will forward it to her now so that she can email that to you.
Okay, thank you.
Hello, excuse me, everyone. I will not be emailing the slides. I will share them on eLeader. But in the meantime, you can listen to her, and then you can listen to her. You know what is covered today because I shared the program with you last week already. So you can listen, and then I will share the slides on eLeader. I will not be able to email.
Thank you. Okay, thanks. Just a quick question on my side.
Yes.
Because in the beginning, I think there was a lot of interruptions. If she can just recap, because I also had issues. If she can just recap on the introduction, not to put everything, but just a recap, and then we can continue.
Okay. All right. Okay. Let me recap on what I've said earlier. As I said, to then say that the introduction to this module goes more with not only when the person is appearing in court. This happens with as at the time when you get instructions from family members or whoever, then that request your help. Then once that person gets your help, you then go and see to it that you visit this person at the prospective police station, secure that person's release, either by him being released on warning or by him getting bail. And if the person is then released, then the matter is then before court. When the matter is before court, whoever will then appear in court, then you guys will interact with the prosecutor as to what is the way forward in the matter. Then once that as well is done, you have satisfied your client, then you have resolved whatever the problem was, the matter is finalized. Don't think that is the end of the world. They would still normally come to you and ask for advice as to what is it that needs to be done. Any opinion as to what will the way forward be? Will I have a criminal, a criminal record? Or will this affect me in the future? You'll still get some questions, and then you'll still have to then advise your client as to the way forward. Then I went further to talk about the sources that we use with regard to our criminal procedure. Then I then said the most important one is the Constitution as it is the supreme law of the land. Then I even then said that we rely on case law, we rely on common law, we rely on other statutes. I even said that there's this pocket book by Juta, the one that it's handy, you can quickly peruse whatever that you need to go through in court other than having to go to the library and whatever the case is. So once you then know where to get information when preparing for your matter, then you are now able to be able to prepare your matter to the best of your ability. Furthermore, I said you can even rely on textbooks, but if you go for the textbooks, just get the latest edition. As I said, our law develops on a daily basis. There are case laws that are decided that have effect as to some of the laws that have been written. I even gave an example as to the Criminal Procedure Act that we are using has since then been written in 1977. So it's been a while. But with the development of case law and other statutes, there are amendments with regard to that. Then furthermore, I still said, even if you do your research, there are articles written by our fellow colleagues who are doing their masters and their doctorates, of which they are researching on a particular topic, of which that topic might then be handed to you. So is there any other question up to so far? So are we together? Hello?
Yes, we are.
Yes,
okay.
ma'am.
Yes. Then I would like to then explain to you the participants, the role players in a criminal court practice. We have members of the SAPS. They are the first people that get into contact with your client. When your client gets arrested, he's been arrested by members of the SAP, but not only the SAP, even law enforcement officers, either the metro officials or the traffic officers, because it might be that the offense was more of a traffic of violation of a traffic rule, which happened at the time a metro officer or a traffic officer is there. So they fall under the same category of law enforcement or as well as members of the SAPS. So those people are the ones that are the first people that come into contact with your client. Then once your client is then being detained or arrested, he is being booked in the cells at a particular police station, then he is then being charged. As I said, there is a notice of rights. Once that person is charged, we call it SAP 14, whereby there is notice of rights to then say you have a right to legal representation, you have the right to remain, all the rights are then being explained. So once his rights are then being explained, then that person will then be formally charged and he will then now have to appear. Then come the following day, the dockets are being sent to the prosecutors. Then we have the prosecuting authority. They then have to go through the docket, read the docket to see if whether there is a case your client has to answer to. If yes, there is a case that your client has to answer to, then they will then place the matter on the roll. Then if they feel that your client, that there's still some evidence which is not in the docket, they won't place the matter on the roll and then they would not enroll it as at the time. Then your client will then be released and the investigating officer will then be given instructions as to which statements to obtain, what is it that he needs to do before the matter can then be re-enrolled again. So once that information is being obtained as per the instructions of the prosecutor, then it will come back as a decision docket. Then the prosecution will then decide, do they have a case or not? So furthermore, if the prosecutor at your client's first appearance, they feel that there is no case that your client has to stand for, then they won't place the matter on the roll. Then we call it nolle prosequi. They decide to decline to prosecute. So nolle prosequi, in other words, meaning refusing to or denying to prosecute. So if your client, they don't prosecute him or her, then he will then be released, he'll be scot-free, which means there's not enough evidence that based on the information that they have, that they can then believe that your client will have the right to or his day in court. Then from there, he goes home, or he goes home through not being enrolled due to lack of evidence. They're still going to investigate further, or there is a case, they believe they have a prima facie case of which then your client has then have to face his day in court. So that is the role of the prosecution. As I said, they are the ones that are dominus litis. They are the ones that decide what to do with the matter or what not to do with the matter. So sometimes you'll find your client stole things to the value of 20 rand, and they will see that, but it's just 20 rands, and we don't have to waste all the resources. He's a first-time offender, and they can decline not to prosecute, and your client will just go home. So another participants as well, we have witnesses. Once the state is of the view they have a prima facie case against your client, they will investigate, then they will then call witnesses to come to court. So when they call witnesses to come to court, witnesses are being subpoenaed. by the clerk of the court. They get instructions from the prosecution. Prosecution gives the clerk of the court, call this person, call this person, call this person, so that they can then be able to help them to prove their case. So we have two types of witnesses. We have state witnesses. By state witnesses, we refer to the complainant, the person who is the victim in the case, as well as people who saw what happened on the day in question. Then those people will then come to prove your client's guilt beyond reasonable doubt. Then on the other hand, we have defense witnesses. By defense witnesses, we mean people who will come and testify in court, who will then come and help to prove your client's innocence. But however, don't forget, your client doesn't have to prove his innocence to anyone. So the state, he who alleges must prove. The state is the one who has to see to it that your client's guilt is proved beyond reasonable doubt. Any questions up to so far? Any questions?
Sorry, ma'am. You mentioned that the state witness is the complainant themselves. Did I hear correctly?
Yes, yes. Is any other person who provided information to the state that will then help to prove your client's guilt. So as I indicated to you, either is the complainant, the victim, the person who was his rights were infringed, or the person who saw what happened on the day in question, or sometimes the police officers as well, they become state witnesses because they would have attended to the scene and found something happened or saw something happening. Have I answered your question?
Yes, ma'am.
Okay.
Yes. Good evening.
Yes.
Yes. Earlier on, I made a mention of a pocketbook by what Sneyman. So that talks to
it's
the.
by Juta.
By Juta.
Yes, it's a Criminal Procedure Act. It's in a form of a pocket book. As I say, it's very handy because you don't have to carry like 300 and something A4 pages every day on a daily basis. But then there is this small pocket size act that can fit in your, as it says, pocket book. It can fit in your pocket or just be able to carry on a daily basis.
Okay, thank you very much. I just wanted the name. Thank you.
Okay, no, it's a Criminal Procedure Act pocket book. Is being published by Judah.
Okay, thank you.
Pleasure. Let's proceed. Furthermore, we have correctional services. So once your client is arrested, he's brought to court. After being brought to court, he's been prosecuted. Once he's been prosecuted, then either he awaits his day in court by finalizing the matter in a form of a plea and trial, or they mediate, or he pleads guilty. It depends as to what your instructions are. So if your client is not released from custody for whatever the reason is, either your client has a lot of previous convictions or has pending cases or can't afford bail, or maybe his family members don't want him home. So there is a reason why he is not released. So that person is kept in here in Pretoria. We have a New Lock prison, Hosi Mampuru, where our awaiting trial prisoners are kept. So once he appears in court, then from there we have a J7 that has to be written by the clerk of court, where the court orders that he be kept in detention, where, as I said, here in Pretoria at Kosi Mampuru. So that's where the correctional services now kicks in. So that person will be transported by members of the SAPS. They are taking him to New Lock, where he will await his next following court appearance. Then on the day in question is the duty of the SAPS to go and fetch him, then for him to come and appear in court. That's how the correctional services feature. Then, on the other hand, it depends. At some point, your client is facing a serious offense of which the sentence the court might give amounts to direct imprisonment. Then when it amounts to direct imprisonment, you are of the view, but he has a fixed employment. This person is not a suitable candidate for a custodial sentence and all things like that. You then request we call it a pre-sentence report, of which on top of the pre-sentence report, which is drafted or compiled by a probation officer, social workers that deals with criminal matters, we call them probation officers. And on top of that, where the social worker would outline the reasons why you are of the view that your client is not a suitable candidate for a custodial sentence. Then on top of that, we suggest that let my client be released on parole or house arrest, whatever the situation is. But then we start first with house arrest. And then if you can check, house arrest is governed by section 276(1)H and 1I, 276H and I of the Criminal Procedure Act. How do we know them? By 276H, we refer it to home, and for 276I, we refer it to in custody. So when each court has a correctional officer who deals with specific duties to see that the address of your client is confirmed, that your client won't be evading or absconding or leaving the country, then his moves will then be monitored. That report as well is, we call it correctional supervision, is compiled by a correctional officer. That's how they play a role in terms of criminal procedure. Sometimes your client has then been sentenced, or he ran away for another matter. Then whilst out on parole, he committed another offense. When he then committed another offense, that would then be brought to the attention of correctional officers, whereby they will go and look for him. He goes back to custody to finalize his sentence. And when now this current matter he's been looked out for, he has to be then brought again by correctional officers. That is when you can see people coming to court with shackles on their legs. Then you wonder to say, oh, what's happening with this one? Only to find that there is a further charge. There's something that whilst in custody or whilst out, he committed another offense, but he has to be kept in custody to finalize that one in order to come and stand in for this one. Are we together?
Yes, ma'am, we are together. May I ask
All
a
right.
question?
Yes.
Yes.
I want to check, ma'am, regarding the confirmation of the address. I want to understand, perhaps, how do they confirm the address?
The issue of the address, once the accused person is arrested, they take his personal details. On the last page of the cover of the docket, not the outer cover, the inside, on the last page at the back, is where we have personal details of the accused person. We have his full name, surname, ID number, date of birth, as well as his address. So the address that he provided as at the time when he is arrested is the one that will then be visited. So the investigating officer will go to this address to go and find out if they know this person. Is this person staying there? For how long has he been staying there? And then they will then dispose that into an affidavit to say, I visited this address, and then the address is positive or negative. This is in terms of section 50, subsection 6 of the Criminal Procedure Act. So that's when it's address verification. Let me give you an example. Let's say, for instance, your client was arrested and his address was not verified at the police station. He will have his day in court as his first appearance. Once he appears in court as at that time, then the prosecution will apply for the matter to be postponed in terms of section 50 subsection 6D, whereby they will go and verify his address. The state has not more than 7 days to do same. So they will give instructions to the investigating officer, please verify the address of the accused person for bail purposes. So they will go and check, then they will come with the outcome. If the address is positive, and the second step is that part whereby the client has to give you instructions as to whether he has previous convictions or pending cases. And this is in terms of section 611B of the Criminal Procedure Act. And if the client has previous convictions and or pending cases and or warrants, please take note, you have to advise your client of consequences of non-disclosure of his criminal or criminal record, because other clients, they would like to take chances. You even know them, but however they'll say, oh yeah, no, I don't have any previous convictions or pending cases. But now for bail purposes, the onus is on them to can then provide to the information to the state so that they can then be able to see if whether they are suitable candidates to be admitted to bail or not. Do you understand?
Thank you, ma'am. I understood.
Pleasure. Then furthermore, the other role players that we have is you, the defense legal practitioner, as well as your client. Now, you as the legal practitioner, you have to then see to it that you take care and proper care of the interest of your client. Not then that you have to do something unethical, no, but you have to see that your client's rights are not infringed. But however, you will see when you are now in practice that some of the things don't go as they are expected to go, but then it's not upon you. You are governed by, you are a creature of instructions. You follow what your client instructions are. Sometimes the client will give you wrong instructions or mislead you, but then if those are your client's instructions, you place it on record to then say that this is my client's instruction to say this. And when sometimes they see that, oh, things are bad, then they were lying to you, they will amend their version, or they will then be able to come up with a story. And don't forget, it's your version against his version. They will try to badmouth you at all costs. But however, due to the relationship or the trust the court has with legal practitioners, they will definitely be able to believe what you are then saying to the court. So the relationship that you and your client plays a very important role, because this as well will have effect to the outcome of the case up until finality. So we have the client as well as the legal attorney as to how then do we go about finalizing the matter. And don't forget that both the judiciary, the NPA, they have a duty as well to expedite and to bring matters up to finality as quickly as possible. So those are the role players, not forgetting the courts, the judiciary, the bench. So we have various courts in South Africa, starting from the Constitutional Court, the Supreme Court of Appeal, the provincial and local divisions of the High Court. Yes?
Sorry, ma'am, can I ask a question? I'm sorry to disturb you.
Yes.
I wanted to ask, what is a requisition? I've heard a lot about a requisition, and I am not sure if I understand what a requisition is. When do you ask for a requisition?
For requisition, okay. Let me answer to this. We requisition someone. Let's say, for instance, your client was supposed to come to court today. Today is the 1st of August, and your client is in custody. While your client is in custody, as I said, is the duty of the SAPS as well as the correctional services to see that he's been prepared and is brought to court on the day. Then it happens to then say that your client is not brought. Let's say, as I said, the 1st of August, he is not brought to court today. Then what then do we do? Then we will have to request the investigating officer to go and look out for him in prison and bring him to court. That's basically what requisition is. So he failed to come on the day he was expected to come. So as a result, the IO has to then go and look out for him so that he can then be brought to court. So what normally happens here, sometimes our clients, they don't answer to their names. Some of them, they say it's nice to be in custody. They make more money in custody, so they don't want to come. Or the client is aware that the matter today is on the roll for plea and trial, and witnesses will then be here. So when his name is called out, preparing for court the following day, he doesn't answer to his name. So we are expecting him here to be here today, but he doesn't come. So when he doesn't come, then it's a bit of a problem. We call out, he didn't answer to his name. Then we then arrange with the investigating officer that he didn't come. There is a paperwork that needs to be completed and signed by the prosecution as well as the state for that orders him brought to court the following day or whatever the date is. That's requisition.
Thank you so much, ma'am.
Pleasure. Yes. So as I
Sorry,
said,
can you hear me?
Yes, I do.
the requisition is only done when the accused is in custody, right?
Yes, yes.
Oh, okay. All right. Thank you.
Yes, only when the don't forget, as soon as the matter is remanded where your client is in custody, then the court orders that he be detained at, let's say for instance here at Khosi Mampuru, at correctional facility. And they give a date as to when must he be brought back to court. So the J7 is issued up until the date the court orders him to come. So should it then be that he doesn't come, so which means this person now is in lawful detention at Khosi Mampuru because the date that was given to him has expired. That is why it's the duty of the IO to physically go and look out for him so that he can then be brought to court, and then the matter, if he's kept in custody again, he be in lawful detention. Because should it not be, someone will then be sued, and should something happen to the accused person. Have I answered your question?
Yes, thank you.
Pleasure. As I said, we have the courts, the high courts. I stated we start with the Constitutional Court, the Supreme Court of Appeal, the provincial and local divisions of the High Court. We all know of that. Then we have lower courts. By lower courts, we have regional courts as well as the district courts. So as with lower courts, it depends with the offense before the matter can then, as well as the schedules before the matter can then be referred to the regional courts. Like as of today, there is a new amendment due to this gender-based violence, whereby the Criminal Law Matters Amendment Act has been updated, where all the gender-based violence matters will be tried in the regional court. So where there was no weapon, they would then be tried earlier in the district courts. However, from today, all the GBV, because our country is facing a serious problem with regards to that, all the matters are now referred to the regional court. So in terms of lower courts, we have the regional court as well as the district court. It depends as to the type of offense where the offense need to be tried. Then furthermore, we have employees of the Department of Justice. Who are the role players in court? Who does what in court? We have the clerk of the court, we have the stenographer who is operating the machine, because all the matters are mechanically recorded, unless now with this power failure, load shedding, we have a bit of a problem. Some other magistrate opt to do things longhand. When the magistrate writes down everything in his own writing, we call it a longhand. Other than that, most of the procedure is mechanically recorded and can be retrieved when at a later stage you really need to listen to whatever. So everything is captured on the machine, and the person who operates that, we call it a stenographer. And then furthermore, there are court books. The court books are by days of the week: Monday, Tuesday, Wednesday, Thursday, Friday, and there's a book for all the first appearances. Everybody who is then now being arrested is brought into that book, who will be appearing, and when the matter is postponed, it will then be postponed to a different date. If, like for instance, the 1st of August was on a Monday, if the first appearance was last week and it was postponed to today, the name of your client will be found on the Monday court book. So Monday court books, all the dates for Mondays are in one book. Tuesday, Wednesday, Thursday, up until Friday, just like that. So that is being controlled by the clerk of the court. And the clerk of the court is in charge as well of charge sheets. We call them the J15s, whereby they set out the details, which police station, the case number, the cast number, and all the personal details of your client, as to the portion, as well as to what the outcome of the matter is. That is kept by the clerk of the court. Then the most important thing in court, ethics. We know then that things are tough. Now people do things that are unethical, people do tout, people take instructions, of which they are not supposed to do that. So based on that, we try as much as we can to even teach our candidate attorneys to please stay away from all the unethical behaviors, because should you then be found, the Legal Practice Council won't be happy with that, and then you might see your face on the other side of the fence. So take notice of that, of being ethical and the etiquette as well. Respect your colleagues, respect the court, so that we can run an efficient court practice. Lastly, I would like to talk in terms of the procedure in terms of conflict of interest. We see most attorneys, and I understand that things are tough out there. People need some cash, they need money. They will double book at some point, have a matter here and a matter somewhere, or even take instructions from two. Let's say, let me give an example. You are having multiple accused persons. And then when facing with multiple accused persons, you then realize during your consultation that there is conflict of interest, which kicks in. So as a legal practitioner with good ethical values, what then do? You withdraw. Because which case are you going to take, or for which person are you going to take? Are you going to take mine, which is you think you will win it, or you will think you'll take the other one because you won't take the other one because you feel that your reputation will be at stake? He will then be convicted. So for safety and, as I said, let's maintain our ethical values. You don't take anyone, you withdraw as attorneys of record. Sometimes as well, your client gives you various instructions. You consult with him now, he gives you this version. After a day or so, he gives you a different version. And one person can give you 4 set of incidents that of which emanates from one set of facts, of which it can be. There's no way that can then be possible. So then what then do you do? Which one to take? Which one will you think is better off other than the other one? Should you then be faced with such instances, the best way, the best advice that you have to then go through is just to withdraw as attorneys, or as attorney rather, of record. And any questions? Any question?
Hello, madam.
Yes.
I just want to take you back. I want to find out how do you verify address of the foreign national, either legal or illegal?
Okay. Irrespective of the status of the person in the country, each person has a permanent fixed abode where that person stays. That's the first part that we have to deal with. So he will say, I stay at number so and so, and I've been residing there for so many years, and I'm staying with this person. So it's the duty of the state, of the investigating officer, to go and make sure that indeed that person stays there and stays with people he says they stay there. What they normally do is, in practice, they will go and the family members will show them their clothes, they will show them their passports, and then the IO will take their passport so that they can secure that that person doesn't leave the country. Because without the passport, that person can't leave the country. So that's another thing. Then the second thing, if that person's status is illegal in the country, as a result, should this person be released, irrespective of whether his address is positive or not? Where are we going to find him? So normally the state in this instance will oppose that person's release on bail. But however, should it be that it's your client's instructions to say that I want bail, there's nothing you can do. You would have then advised your client, due to the fact that your status in the country is illegal, prospects of you getting bail are very slim. So as a result, then you proceed with a formal bail application, and he has to prove that the interest of justice permits his release on bail. And should the court finds it that he failed to disclose the honors on him, bail will be refused, and he will then be kept in custody up until his matter is finalized. But on the other hand, if they are certain about his status, they are certain about the address that he provided, they can then say, provide us with your passport, and the court can add further conditions to then say, let this person then report at the nearest police station, maybe twice a week or thrice a week between this time and this time, just to monitor his moves in the country. Have I answered your question?
Yeah. Yes. Thank you.
Okay.
Excuse me, ma'am.
Yes.
Hello, ma'am.
Yes.
My name is Kennedy. I was just making an inquiry. For example, during the Sense of Your case, I don't know if you've been watching that case.
The Mayua case?
Yes.
Yes.
The representative of the 4 accused was accusing the court of unfairness and a lot of things. For academic purposes, what is your opinion of his comments in terms of what you're saying of respect and...
Okay. Even though it's not part of this, but this will go in terms of the ethical conduct of the legal representation. According to my understanding, what the counsel was doing is not in accordance with what is expected in terms of etiquette, as well as in terms of, respecting our courts, and he's putting our name into disrepute. Because when people look at it, they will then say, oh, but our courts don't take our matters seriously. This is not what is expected to be. But however, I think if he was party to, or he belonged rather to either to the Pretoria Bar or to some governing body, I think his conduct would have then been different, because he would have known to then say that a particular body will take action against me of what I say in court or what I do in court. I'm not sure if I've answered you properly. Hello? Hello? Can we proceed now to the pre-trial stage?
Yes, ma'am.
Yes.
Yes, please.
Okay.
Yes.
In a pre-trial stage, what happens is that anything that happens before the matter is proceeding to trial. That's why it's called pre for before. So if, let's say, for instance, the state has finalized their investigations and they are now ready to proceed with trial, what will then happen? The state will then have to provide you with copies of the docket. Every person has the right to be provided with copies of the docket so that you can take proper instructions and be able to prepare for your defense in a good way. So the court will order the state to give you those copies, whether represented or not. What will they normally do with unrepresented accused persons? Are you conducting your own defense? Do you want copies of the docket so that you can prepare for your trial? And should the client then say yes, he wants them, then such documents will then be given to him. So once you receive the copies of the docket, you know what the state's case is all about against your client. So you will have to then have a consultation with your client. Don't forget, we have already passed that stage whereby family has already approached you and all that. And then you then have to then sort out your fees. Then to then say that, oh, okay, the matter is ready for plea and trial at this stage. But before we get to that, we then now have to then sort out the fees. Because at the end of the day, we have to survive. Our families need to survive. Then as a result, we have to then be paid. So if you agree with your client as to how to pay, you arrange, that will be sorted, that will then be settled. But should it be then that your client can afford the fees that you would have requested, so it's your duty as the legal representative to then advise your client as to there are some forums that help people who can afford for legal representation. So once that is being done, either you refer your client to the Legal Practice Council at the pro bono committee, whereby a pro bono attorney will be appointed to him, or the person will approach the law clinics of the different universities. All the universities have law clinics whereby they assist clients for free, and the client can approach the Legal Aid Board of South Africa, whereby an attorney will be appointed to the client for free. So what they used to do is, in terms of civil, there's a means that is being followed, but in criminal matters, as like now we are dealing with specifically criminal matters, is the rights of the accused that he or she be legally represented. Are we fine there? Is there a question? Then let's proceed furthermore with rights of the accused. The accused have rights. Firstly, the accused has a right to remain silent. So as I said, this is been entrenched in the Constitution in terms of Section 35, whereby the accused has a right not to say anything or incriminate himself or say anything that would then be detrimental to his case. So what will then have to be, because don't forget, at some point, the accused people are being threatened, are being forced or put under duress then by the police officers because they want to see to it that they get some information out of the accused person. So sometimes the way in which they get the information is not in a good way. So the accused person has a right to remain silent, and no one will even force him to say anything either before trial and even during trial. Then the accused person has a right not to say anything. But according to my experience during the trial proceedings, what I've realized is that when you exercise your right to remain silent and not say anything before court, the only evidence that the court has is from the state side. So your client's evidence is not before court, then the only evidence the court will work upon or will make a deduction out of will be the only one before court. And that is this is a very dangerous game that you need to play. But as I say, experience taught me for a while to then say other legal representatives as well try to amend. They will, in their opening statement, they will then say that, no, we exercise our right to remain silent. But during the trial, during either the examination in chief or during their cross-examination, then they will then hint a defense that they will then be coming to use at the end of the day. But however, your client has a right to remain silent in a pre-trial proceedings as well as during the trial purposes. Then the second right, your client has a right to give his statement to the police. In the police docket, there is we normally call interview with suspect, whereby the police will try to get information from your client as to what happened on the day in question. And this is very important. Please take note of this. There is chapter 4 thereof, whereby your client's rights are being explained, and the police do not adhere to that. They will further take your client's statement. He would opt to have his legal representation present, but then they say, what effort did you use to secure that? Then they will say not applicable and continue to take your client's statement, of which at a later stage, that statement rather cannot be used against your client because that statement was not properly obtained. So take note of that when your client is willing to make a statement, he or she is very sure of what he is putting himself into, or you as the legal representative, you are there to then secure as to his rights are not infringed. Then, furthermore, right to access to prosecutors' documents. By prosecutors' documents, we refer to the docket, because other than the statement that are in the docket, the prosecution won't then be able to proceed with their case without that. So this is, you find them in the A section. So the docket is divided into A section, B section, and C section. So, sorry, the B and the C section are mostly for their investigative journalism, their diaries, and everything. We are only entitled to the A section, whereby even when you prepare for trial, they will make copies for you of what is in the A section. So the statements are written A1, A2, A3, up until it depends as to how much the evidence is. So when you then get the docket, the first statement that you have to look out for is the A1, because the A1 is the statement which is provided either by the first person who saw, or by the victim, or any person who was at the scene as at the time, meaning the first person to be there. So you are entitled to the contents. When you consult with your client, you know exactly what evidence will the state then bring against your client. And furthermore, as a matter of courtesy, don't ambush your trial. If there's something that you would like to bring to the state's attention coming from your client's bring it to the state's attention to then say that I have evidence as well that will prove my client's innocence, or whatever the case is, because that will determine the outcome of the case. So as you and the prosecution have a relationship as colleagues, then see to it that whatever you'll bring forth will be detrimental to your client's case, or will this be helpful to your client's case? So you have access to that. Then the right to legal representation. This is normally explained as soon as the client appears in the dock. Is the duty of the court to then explain the client's right to legal representation. The client's rights will then be explained as to he has the right to legal representative of his own choice, or he can conduct his own defense, or he can get legal aid. So out of these three rights, the client has to choose each one that will be best suitable to him. What will happen is, if he can afford to pay for an attorney, he will say, I will opt for my own legal representative, whereby the matter will then be postponed for some time, either a week or 2 weeks, or whatever the period that the client would have requested for him to be assisted in securing legal representation. Or if he then says, no, I'll conduct my own defense, meaning that he will talk for himself, he doesn't need any assistance of any legal representation, then in this instance, the court will be the role player in helping him to see that his rights are not infringed. And then the third one, he will then opt for legal aid, of which all the courts in South Africa have legal representatives, whereby from Legal Aid Board. However, here, because of the jurisdiction of the University of Pretoria, we are based here in Hatfield. We provide free legal services to the indigent at Hatfield Court without any remuneration. So we then come on record, but we do the same work as Legal Aid does. So out of the three, then the court will have a clear indication, will endorse in the charge sheet to then say that the client opted to choose for legal representation or own defense or whatever the case is. And then the presence of legal representative at pretrial proceedings. This is very important as well, because should it then be then that your client's identity is an issue, the complainant doesn't know who the person committed the offense or doesn't know the person who robbed him or doesn't know what happened. Let's say, for instance, you don't know your car was smashed. All of a sudden, you just get information to then say that there are 2 or 3 people arrested. Will you be able to come and identify? Or do you know the person who assaulted you? Or do you know the person who committed this offense too? Then if the person knows, then you will say so and so. If the person doesn't know, then they will say, no, we have so many, we have someone who was arrested. But this is very important, the issue of the identification parade. It should not be dealt with by the police who is investigating the matter or the police from the station where your client has been arrested. They have to arrange with their fellow colleagues from other stations whereby they will then be able to come and conduct the identification parade, because that person will be impartial, doesn't know your client, doesn't know anything about the facts. And the other thing, I remember I once attended same in yesterday's police station, whereby the procedure was not properly followed. If, let's say, for example, it must be someone in the ages between 20 and 21 of a colored origin who is light-skinned, who shaved his head or whatever the identity is. All the people in the lineup should be of a similar characteristics, because if not, or description, if not, your client can be easily pinpointed out or identified, and this will evade the purpose of why we had the identification parade. So it's very important, should it be then that your client's identity is at stake, avail yourself and be able to go and see if whether the proper rules are followed. Furthermore, in terms of interrogation, as I said earlier, most of the accused persons, they will then tell you to then say that, hey, I was tortured, they assaulted me, starting from the arrest. And then from there, it will then be then that to then say that when they get information from your client, you are there so that you can then see to it that your client is not interrogated. Then the other right, this is very important, of which sometimes the police don't adhere to, whereby it talks of the right to be brought before a court within 48 hours. This is very, 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 very important. And then this is governed by Section 50 as well of the Criminal Procedure Act, as well as the Section 35 of the Constitution, whereby your client has a duty to be brought to court as quickly as possible within 48 hours. And this as well is a bit of a problem, because the court sits from 8 o'clock up until 4 o'clock. So they would try to force issues because they are scared that your client will have to then appear later than the 48 hours, and they don't want the matter to be struck off the roll. So guard against as to the time. When was your client arrested? does this fall within the 48 hours? And don't forget, if the 48 hours expires on a weekend, he should then be brought to court on the next following day, of which then that is very, 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 very important in terms of that. And don't forget as well that your client has a right to a speedy trial, whereby even if your client, there are delays, the prosecution keeps on postponing for further investigations, but be firm in respect of the timeline. But what time do you need? Can we postpone for a week? Can we postpone for 2 weeks? And furthermore, be on the alert. If you didn't bring it to the court's attention to say then that you request this postponement to be marked final, which means the court can still on the next occasion postpone it. It cannot be marked final and final. You understand? So at the end of the day, be wary that your client's matter has to be brought before court and be finalized within a reasonable period. That is the right to a speedy trial. Do you guys have any questions?
Yes, ma'am.
Yes.
I have a question.
Good evening.
Evening.
Ma'am, I just wanted to comment on the 48-hour period. Being
Yes.
that the accused person is maybe arrested on a Wednesday afternoon.
Yes.
4 p.m.
Yes.
So does it mean that the police can just arrest the person, keep the person in custody until after the court closes at Friday, 4 o'clock, not working on that person within that 48 hours, misusing their power to keep that person until the next Monday?
Yes, that would be unfair to your client. However, it will still determine on Wednesday at what time. So if your client was arrested on Wednesday afternoon, then after 4 o'clock, then which means the 48 hours will then expire Monday afternoon at 4 o'clock. But then if maybe then your client was arrested on a Wednesday before 4 o'clock, which means then his 48 hours will then expire on Friday before 4, which means he has to then be brought to court before 4 o'clock on Friday. So what is important as to the time of the arrest?
Yeah, let's go on the notion that it was after 4 o'clock.
Yes.
On a Wednesday afternoon.
Yes. So
now, if the
yes.
police want to misuse their power,
yes.
they will just lock up that person.
Yes.
And forget about the person until Monday morning.
Yes.
Not taking any statements or investigating the matter. Just on a Sunday morning, rushing to the police station and they now start all of a sudden working on that person, or even on a Monday morning before that person is sent to court. So it means for the 48 hours, the police did nothing to proceed with the investigation on that particular case. So
I understand that. Yes. Yes.
Yes.
Yeah, but then, however, don't forget to then say that if it's after 4, they will bring any excuse in this world to then say that they could not then bring him to court on Friday. They will then say, oh yeah, we didn't have transport, our systems was off so that we can profile the accused person, because all this have to be done before the person is brought to court. So they will come up with any excuse in this world that they will get for them not to do it, whereas only to find that they were just spiteful. And some of the excuses that they bring up, there's no way you will defy them. You were not there unless if then you can then bring it up at a later stage to then say, but I have evidence that this is what happened, this is what happened, this is what happened. But then with the 48 hours on Monday will still be applicable, but that can be you can take them for a lawsuit, and then that will just then be. I'm not sure if I've answered you.
Thank you, ma'am. Settled.
Ma'am,
Can I
just
ask?
make a follow-up?
Pardon?
Can I just make a
Can I
follow-up
please ask?
just on the question that was asked?
Yes.
Yes, if you were able to, how will you be able to obtain the information for you to be able to institute a lawsuit? Because any divergence of such information from their side may actually incriminate themselves. So
Yes.
how will you be able to independently obtain that kind of an information to prepare for a suit? Thank you.
Okay. That will only be from you, the legal representation side. If, let's say, for instance, you were there at the police station and then you wanted to see to it that your client appears within the 48 hours, and then the IO is there, but he's not doing anything. There are cars there, but nobody is saying anything to you or whatever. Other than you, the legal representation, coming up with such information, putting it down on paper and bringing even up to whoever senior is, then to then say, but this is not fair. Here are the cars. They are just loitering here. Nobody is doing anything, and my client has a right to appear within 48 hours. Is then that you can then be able to take it up. But other than that, getting this from your client will be his word against their word, of which your lawsuit might not have weight.
Thank
Hello.
you, ma'am.
Yes.
Hello, ma'am.
Hello, can I ask, please?
Yes.
Can I ask the question as well?
Yes.
Okay. My question is based on the right to access to a prosecutor documents.
Yes.
I am not sure if when the accused has access to the prosecutor document, will it not have an implications maybe on the either witness, state witness? So can you just please highlight for me how does the state get to make sure that on the process of having access to prosecutor document, the right of the witness are not infringed at the same time?
Which rights are we talking? Which rights are we talking about? Because don't forget. Yeah, I think elaborate further there.
I'm speaking from the point that when you have an access to a prosecutor documents, you might see maybe whom is the witness.
Yes.
Then what might happen is that can I not as an accused now approach the witness and make all the threats so that they can withdraw the case?
Okay. If it comes to the attention of the state that your client is threatening the state witnesses, don't forget your client would have then been out on bail, and one of the conditions that normally the court sets is that he must not have contact directly or indirectly with the complainant or the state witnesses. And furthermore, this would have then been one of the grounds that the IO would have highlighted in his bail affidavit to say, no, I'm refusing this person's bail because I know this person might infringe or might interfere with our investigations or with witnesses. But I'd like to bring it to your attention to then say we are having a serious problem with this because people rush to police stations to go and open cases and they make money out of it. I'm sorry, but we see it on a daily basis happening. So they go and open cases. After that, they talk to the accused persons. If you give me 2,000 rands, I will then withdraw charges. And then at the end of the day, your client wants his name to be cleared. They settle the matter out of court. He gives him the 2,000, then everything is settled. So the aim of providing you with the prosecutor's documents is for preparation for trial, so that you don't have to be ambushed during trial and not knowing what evidence is against your client, so that you can prepare very well as to A1 will come, the complainant will come and say this, the witness will come and say this, this is what happened, this is the exhibit that were found that are booked in the SAP 13, so that you can prepare very well for your trial. That's the sole purpose thereof.
Ma'am, can I just
have
one
one question
on the
as
48
well.
hours, please?
Can it be one person at a time so that we give each other a chance?
I just wanted to know whether I can have a follow-up question on the 48 hours.
Yes, you may.
No questions.
Yeah, I just wanted to know the commencement of the 48-hour period. Is it the actual time written in the cell register or the actual time when the accused person was arrested?
As at the time when the offense was committed. As at the time, if let's say, for instance, it's a roadblock there and the incident happened now at 17:33, the time starts kicking in now at 7:33. Then that's when we start calculating the 48 hours, not as at the time when the person is charged at the police station.
No. I wanted to know.
Yes.
There's a time when the person is arrested at the roadblock.
Yes.
And then there is a time when the person is actually processed in the charge office.
Yes.
So that time indicates that the person was at a police station at this particular time, locked up and processed through the cell register into the cells.
Yes,
now,
that SAP 14, yes.
Yeah, but is it that time which counts, or is it the actual time when the person was arrested at the roadblock?
Initially, it's supposed to be as at the time of the arrest at the roadblock, because the arrest didn't happen at the station. At the station, he was only taken there for him to be locked up. But when did the incident occur? The incident occurred in the street as at the time during the roadblock. So, but they are not doing it in the right way, because they know people don't know their rights, and the issue of the 48 hours is still a problem. People can't really count it up properly.
So thank you, ma'am.
Yes.
Hi, sorry, I just have one question as well regarding the 48-hour rule.
Yes.
My hand is let's say that, like you said, the client was arrested on a Wednesday, and it was a Wednesday evening. And the police are being spiteful. You know, they want to make sure that the client stays the weekend in prison. Then, if they are doing this, is there anything you can do to speed up the process and get your client released?
It depends with the type of the offense. If the offense the client is being faced is Schedule 1 offense, there are prosecutors that are on standby even now as we speak. Each magisterial district have prosecutors allocated to areas. So you find out who the prosecutor on standby is. Then from there, you call the prosecutor to then say, hey, my client is being arrested and I don't want my client to spend the whole weekend in custody. But before you do that, see to it that his address is verified, his profile is clear. You understand? Because the prosecutor can't just leave home and come to entertain your client's issues, whereas he'll say, but there's nothing I can do. I can't fix bail now, whereas this information is not there. So that is why I say before, see to it that your client's, what do you call this? Address is verified, your client's profile is being in the docket, then you call the prosecutor who is on standby. Then that prosecutor will then be able to facilitate bail and your client will be released, then will come back on Monday.
Okay, thank you.
Next question?
Yes, ma'am. My question, when does representation come in the picture? Because I heard there is some representation.
To the state, yes, yes, yes.
Yeah, representation. I mean, as an accused person, to say you want to ask your legal representative to make a representation to you so that the prosecutor can decide whether to proceed with the case or not. Does it come during the trial itself, or does it come during pre-trial or before that? That's my first question. And then the second
let's deal with them one by one because it might take a while, and so that we don't miss each other somewhere along the way. The first question, representations is another form of disposing a matter. If you are of the view that the state's case against your client is not so good, or you feel that your client is a student or has a reputable job, or for him to incur a criminal record might jeopardize his prospects of furthering his studies or going overseas with work, or whatever the reason is between you and your client, then you make formal representations to the state prosecutor, more especially the senior one. Then you make representations to say, I'm acting on behalf of my client. We are of the view that the state's case is weak against my client based on this. We would request you that you withdraw charges against the client. Or our client is very remorseful for what he has done. He is very young. He has a future. He studies at UP doing law. For him to get a criminal record might jeopardize his prospects in the future of being admitted, or whatever the case is. We request that the client be given a diversion program. So it's another way of finalizing your matter, but it will depend as what you, as the legal representative, from your client's instructions, what do you want? How do you want this matter to be finalized? Then the second question?
Yeah, the second question, I wanted to find out, can an accused person be arrested without a warrant of arrest? Because my experience is that in most cases, you get arrested, you're only read your rights. It is very rare where an officer will say, I've got this warrant of arrest, I'm arresting you. You get arrested, then you get read your rights, you've got the right to remain silent, what everything. And then this thing of an arrest to arrested, it gets neglected. And then if you are arrested without that warrant, can you challenge it later on, like suing the state or something?
It will depend. There are certain provisions that happen as to why was this person arrested without a warrant. If you can just check your from section 19 of the Criminal Procedure Act to section, I think, 25. But we are still coming to deal with that at a later stage, whereby it explains to you at what stage can this person be arrested without a warrant. One of the reasons might be maybe this incident happened in the front of a police officer. He's a law enforcement officer. He can't just wait for him to go and apply for a warrant, of which is a long process. Then he has the right to arrest. Or should he then go and apply for a warrant, you might dispose of whatever that might take long. Then for him to get a warrant, he can still enforce an arrest without a warrant.
Okay. Lastly, related to that one though, do an accused person get arrested and then an IO does an investigation, or an IO does an investigation and effect an arrest? Because sometimes there's confusion with regard to this. You find that the person is allowed to stay in a cell or in prison for weeks or months. Investigating officer claiming that no, I'm still finalizing investigation before a person can even be allowed to apply for bail. Do you investigate, and then when a case is tied, you arrest, or you arrest and investigate?
I think maybe there's something which you have missed there. Is the accused right to be before court and apply for bail within 7 days? So as I said, section 50 subsection 6, no person has to be kept in custody for more than 7 days without bail. Bail is an urgent matter that the courts have to attend to. So for the person to be in custody for months and years, there are reasons as to why bail was not fixed. So either the court formally denied him bail, that is why he is in custody. Either he is illegal in the country, he won't be nowhere to be found, or there are reasons, or he might even opt not to apply for bail himself. Say, no, I'm fine, I don't have any money, I'd rather not apply for bail. So there are reasons. It's not then that he was kept in custody for months because the police didn't do their job. They would have done their job. Is the court's prerogative to see to it that bail is entertained within 7 days. Can I please attend to Kotato? I see has been raised his hand for some time.
No, it's myself, ma'am. I'm
oh,
okay.
are you Kotato? Okay, okay, all right. So as I say, Kotato, see to it. There is a reason behind that, but your client has a right to bail within 7 days.
Okay,
Any
thank
question?
Yes, ma'am. I wanted to ask with regards to the 48 hours. When an arrest happens for drinking and driving, when does the time of arrest start? Is it when the police stops the accused, or when the engine switches off of the car, or when they're taken to the station?
Okay. The first question is, what is it that the accused did that attracted the police officer to stop him? So either the manner in which this person was driving, or maybe his conduct on the day in question brought a suspicion to someone to then say, hey, something is not right there. So as at the time when this person is being stopped, then that's when the period starts.
Thank you, ma'am.
Pleasure. Can
Thank
we
you, ma'am.
have
Can I ask last question?
Okay, and after this question, can we have a 5-minute break, and then we'll resume after that? But let me attend to this last question.
All right, ma'am. The right to a speedy trial.
Yes.
In practically, there is a lot of remand detainees. I'm not sure if I'm calling them correct, but who are waiting for a trial. You will find that they are in a correctional facility maybe for 6 or 7 months or 8 months, does that amount to right to a speedy trial?
It will depend as to the reasons why are the matters remanded for so long. Let's say, for instance, there is a backlog at the forensic laboratories. And then if something is with either with blood, or if something with the DNA analysis, or things like that, that's most of the things that will take a while. But should it then be that your client can be a suitable candidate to be released on warning, that person will be released on warning and pending his day to come in court. Or the state won't place the matter on the roll pending their investigations. Once they've received the blood or the DNA analysis, then such person will be summoned to come back to court. And then that will then presume the trial. But in most instances, they have their own reasons as to why they are not coming. And don't forget, our clients, not then that I'm bad-mouthing them, they know to get away with the system. So either the person will change attorneys on a daily basis, the matter will start with this attorney, then when it gets to trial, he fires this attorney. He then appoints another attorney. Then the matter starts again. The attorney say, no, I want to be given a chance, and then so that I can consult with my client, I can be placed in funds. Then when the trial date comes, either the attorney doesn't come, not put in funds, or if maybe it then gets to another point, then it ends up being then that, no, I no longer want this attorney, I want the other attorney. So there are so many delaying tactics. But as I say, guard against the issue of requesting investigations to be marked final. Bring it to the court's attention to then say then that this has been going on for so long, we request that to be marked final. Or undue delay, reasonable delay. Section 342 capital A. If you are of the view that the state is playing duck and dive, they don't want to finalize the matter, then the court can order that the matter proceed in terms of 342 capital A, whether finalized or not, and this can happen to the defense as well. So I think let's, yes, it's almost 10 to 8. Let's have a 5 minutes adjournment, and then we will resume at 19:55. Thank you. This is, I just want to say it to me. Why is that so wrong?